providing with their replies to the argument by the defendant. Mr. Brewer, please proceed.
Thank you, Your Honor. Ladies and gentlemen of the jury, you've been here for days. You've heard all of the evidence. And the defense and I will agree upon one thing, and that is that a wall has been built. That wall is around the defendant, Tai Chan. It was built brick by brick by brick. So unlike on the early morning of October the 28th, he has nowhere to hide. He has nowhere to hide at all. He has nowhere to run. He is here before you to face what the state alleges he did to Jeremy Martin. It was uncalled for. Not only that, it was unnecessary. Not only that, it was inappropriate. Not only that, based upon the evidence I submit to you, it was plain, cold murder. If I could have Mr. Prindle. Unlike what the defense has told you, this case is not all that complicated. This is Jeremy. This is the way he appeared before the early morning of October the 28th. A Santa Fe deputy sheriff, married, a whole life in front of him, a whole life to live. This is Jeremy, and he's been cleaned up. But this is Jeremy after what the defendant did to him on the early morning of the 28th. The defense attorney told you, and the state concurs, you are the jury. You determine the facts. But on the early morning of the 28th, the defendant himself was a judge, he was the jury, and I submit to you, he was the executioner of Jeremy Martin, the man you see right here. The defense has a lot to say. I have a short time in which to counter what they have to say. But you have heard all of the evidence in this case. I want to start by what the defendant, Tai Chan, has told you. And the defense has tried to tell you it's no way it can be countered. But what the defendant, Tai Chan, has told you makes absolutely no sense whatsoever. None. Yes, Tai Chan and Jeremy Martin had been out. They'd had a good time that night. They had been consuming alcoholic beverages. The state does not dispute that at all. The state does dispute some of the characterizations made by the defense counsel during closing argument, making reference to some people like Ian Robles and Ernie Venegas. But I want you to recall E.J. Venegas' testimony while they were out drinking earlier. He was called to go over and to try to see what was going on between the two of them. What did he see? He has no reason to hedge his testimony at all. None whatsoever. He's not trying to become a police officer here in Las Cruces, New Mexico. He's over in the state of Texas in San Antonio, probably never to return. And yet the defense would have you believe essentially he's lying. But what happened on the evening of October the 27th? He was a bartender. His attention was diverted to two people. He went over, and what did he see? Jeremy Martin putting his arm around Tai Chan, saying, it's going to be okay. Everything is going to be fine. I submit to you that's the way it went all night long. Tai Chan became aggressive, and Jeremy Martin was the one repeatedly who calmed him down on that evening, to the point where when they were dropped off at the hotel in Kanto, Jeremy put his arm around Tai Chan to help him get out of the car and help him into the hotel in Kanto. Jeremy Martin was the peacemaker, not the aggressor, all night long. And what does the defendant come in here and tell you? That all of a sudden, Jeremy Martin went from the peacemaker to the attacker? And let's look at his story in more detail. Tai Chan's bag was next to his bed, closed, according to the defendant, when he dropped it off in the room. It was a dim night. The defendant said he was in the bathroom. In fact, he was in the bathroom when he told Leah Tafoya, oh, I got punched in the nose. I got kicked in the actual word was, I got kicked in the balls. Didn't sound like there was a severe threat at that point. Later time, he says he came out of the bathroom. There was knocking. Let me the fuck in. Let me the fuck in. Well, I submit to you, that was Jeremy trying to take care of Tai one more time, just like he'd been doing all night long. And what does Tai Chan tell you happened? He came out of the bathroom. Jeremy was all the way on the other side of the room next to his blue bag. So somehow, the defendant wants you to believe that Jeremy Martin had gone inside of Tai Chan's bag, located his Glock 357 SIG, removed it from his bag, walked over to the other side of the room, and pointed it at him, the defendant, and said, I'm going to kill you. Makes no sense at all. When Jeremy Martin, according to the defendant, was right near his own bag in which there were two pistols located in there. And yet Jeremy Martin somehow was going to get Tai Chan's gun and walk across the room and point it at him. The story further makes absolutely no sense whatsoever when Jeremy Martin then says, I'm going to shoot you. He has a clear shot. But the problem with that is, according to Tai Chan, he held it in his left hand. Well, I'm sorry. That doesn't hold true. Because you've heard the testimony from Jeremy's own brother, James Martin. He was right-handed. James had fired with Jeremy many times. Jeremy always fired with his right hand. If you have time to pick up any type of sidearm, you don't pick it up with your offhand. The holsters were right-handed. Now, if you buy what the defendant says, I'm going to shoot you, there wasn't any shot fired. Instead, according to the defendant, Jeremy Martin charged across the room and started pistol whipping him with that handgun, hitting him repeatedly in the face. Oh, I mean, it was a severe beating. And he said, with a handgun, then he said, I'm not sure. But then he came back again, I submit to you, and said it was a handgun, my own handgun. Well, there's a huge problem with that, ladies and gentlemen of the jury, because that handgun was sent up to the laboratory. And you heard from the expert, there's absolutely no blood whatsoever on that handgun at all. None. Now, you've heard testimony there was Tai Chan's DNA on the gun. You've heard testimony that there was a mixture that could not be identified as belonging to Jeremy Martin. But the swabs were taken from the slide area of the weapon, the trigger guard, and the grips. Unlike when the defense attorney held it up and touched this part, that slide, the gun is clear. All the way down, that slide is here. I submit to you what happened in that room that night was that the defendant, who knew where his handgun was located, went into his bag, pulled out that handgun. And yes, there probably was. The state doesn't doubt there was. Something occurred between the two. The only way I submit to you that Tai Chan knew how to respond was to go for his gun. What did Jeremy do then? Tried, as an officer would, to get the handgun under control, or at least point it away from him. That's where, if in fact it was Jeremy's DNA on the gun, that's where it happened. Trying to deflect the gun away. If the gun, I submit to you, is pointed out, and I'm right-handed, so I should do it this way, is pointed out, the logical way to get it to point away from you is to push it up. So, if in fact, and we don't know, if in fact Jeremy's DNA is on that gun, it comes because he was trying to protect himself from death. Unfortunately, he wasn't successful. There was a shot that went up in the air. The state doesn't dispute it. But then there were shots fired at the doorway of room 711. We know at least 2 of those rounds ended up in room 712, right across the hallway. We also know, based upon the testimony you heard from Marvin Zamora, that in all likelihood, and the state will submit to you, based on the evidence, that first shot took out the tricep, rendering him helpless, took out the tricep of Jeremy Martin's arm. He was helpless as he turned the corner. The defendant says, I don't know if he was armed or not, but in his own mind, a trained law enforcement officer, I don't know is not good enough. It's not good enough. I submit to you, at that point, Jeremy Martin was unarmed, was a threat to no one, had lost half his tricep, couldn't use his right arm, and you heard Marvin say as he was running down the hallway, he was holding on to that arm. Ladies and gentlemen of the jury, I'm drawn up here. I'm not a very good artist, so forgive me for that. But there's something to remember. 7-11. This is our room.
And again, Mr. Brewer, please be careful. You might want to bring the easel up a little further. Be sure, or you may want to draw first and then.
I will, Your Honor. Thank you for that advice. Room 711, where both of them were. If anything had happened, that's exactly where it should have ended. right here. I'm making reference to the doorway at 7-Eleven. Once that line was crossed by the defendant, that became a line of murder. Right there, a line of murder. Nothing less than that. Jeremy Martin's helpless. The defendant comes around that corner. And you heard from Mr. Byers earlier, the witnesses on the floor heard a brief volley. But what did they hear after that? As Jeremy was running down the hallway. And if I could ask Mr. Prindle to put that up next. Running down the hallway of the 7th floor, virtually helpless. And what do we hear from the witnesses next? We heard Jeremy groaning, sobbing, asking for help. What did the defendant do? Did he stop? Did he try to get assistance? No. What he did, and this is described by Mr. Bravo, he got into a firing stance, just like this, and you heard boom, 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 boom. Measured shots. Shots, I submit to you, were intended for one reason, and that is to kill. To kill Jeremy Martin, somebody that he'd already shot in the arm. At that point, the defendant knew he was in big trouble. So he took out the only other witness to what occurred. There were two people who were in that room. This defendant and somebody we can never hear from again, Jeremy Martin. We submit to you, however, the evidence shows it could not and it did not happen the way the defendant told you. A shell casing on the other side of the room from the first shot fired up. Shell casings around the entrance room. More important, shell casings outside of the room. And that's not all. Once again, the defense has tried to discredit Marvin Zamora. But this is a diagram which he drew on the stand. And it shows the bottom 0, the bottom O, is where he was trying to have cover, behind a pillar. He saw Jeremy run down the room, or run down that hallway toward the elevator, and he saw the defendant fire repeatedly coming down the hallway from room 711 to finish the job. And that's what exactly the defendant did. As I indicated, I call this the line of murder. Once the defendant crossed that line, it became more than second-degree murder. It became more than voluntary manslaughter. It became first degree murder. There was no one else in the hallway. There was one man running toward the elevator to escape. Well, there was two people there. Marvin Zamora. Now, the defense would attempt to discredit Mr. Zamora, but you heard from him. Not only was he scared, not only was he cold, he wanted to go home. He wanted to get out of there. He wanted to get out of there in a hurry. But he told the defense investigator before this trial started what had happened. Exactly what he said in here today, twice. He's as close to an eyewitness as we possibly can have. Now, the defense would have you believe that the defendant's actions afterwards were calculated to try to get help or try to, protect the public. Well, I submit to you what protecting the public means, because the defendant ran down the opposite hallway. He didn't run back to his room or the area of the room. What he did is run down to the steps. Did he go down the steps? Did he clear the steps to try to get out? No. He ran up to the very top. And where he ended up is exactly where that police tape is, but he actually went further up than that. Now, the defense would have you believe that he did everything that a police officer should do or a person should do when he's in that situation. I submit to you, he did not announce himself until he heard a police dog barking, coming up the steps, and he heard people yelling out, "Police, dog, police." Only then did he start announcing himself as a sheriff's office, "I've got a gun, I've got a gun." Only then, when he was already up at the top of those steps, and I submit to you, based on the evidence, he was hiding. There is a hatch at the very top that goes up to the roof. He ran as far as he could, but he was trapped. He had no alternative. Now, you'll recall Officer Cosper, one of the gentlemen who went upstairs to try to bring him down. Did the defendant come down after it was yelled once? No. Twice? No. 3 times? No. 4 times? No. 10 times. An officer from the Las Cruces Police Department had to tell the defendant to come down. Show me your hands. Show us your hands. The defendant showed one hand. And I'll pardon the language, then you heard the officer say, "Show us your other fucking hand." It took a while. Finally, I submit to you, the defendant put down his gun because he was trapped. He was caught. And then you've heard the testimony. He backed down the steps. And you've heard a lot of ramblings from the defendant from that point forward. There's a bomb in the building. Get everybody out. There's a bomb in the building. I'm concerned about everybody's safety. There are people up on the floor. They're armed. Where are they? Where's a bomb? No, you couldn't tell. All of that was done to deflect the guilt away from the defendant, to take valuable resources from the Las Cruces Police Department to clear out a hotel, to take valuable resources away from the investigation that was focused upon him. Then he gets around to, it was self-defense. I shot him. It was self-defense. It doesn't comport with the evidence. Doesn't comport at all with the evidence that you've heard in this courtroom. Something else, and I'll bring your attention back to it. The defense says, well, we didn't like the testimony, so we attacked people. Far from attacking Leah Tafoya, in my last question of her, I simply asked, you couldn't tell who said, please no, please no. And at that point, her response was honest. No, I can't say who said, please no, please no. I submit to you the please no with Jeremy Martin begging for his life. Don't shoot. Please, no. The defense would have you believe that Dr. Trumpeter, for whatever reason, has a lot to add to this case. Dr. Trumpeter, as you will recall, never interviewed Tai Chan. Anything he said was based upon studies done somewhere in California. And not only that, contrary to what the defense attorney told you, Dr. Trumpeter told you point blank, I can't tell what the defendant's perceptions were at the time because I didn't interview him. I don't know. You'll also recall that one of his conclusions that he mentioned when I asked the question, well, there's eyewitness testimony that says this, particularly from Marvin Zamora. His response was, I withdraw my conclusion. He doesn't know what was in the mind of the defendant at the time because he never interviewed him. The defense also makes a lot out of Dr. Marcinski. Remember, she never interviewed the defendant either. She brought in studies about the mix of Red Bull. She's also the one who told you if you're at a 0.24, you should be in the hospital. But then you heard from Dr. Siegel says, well, it depends upon the tolerance that you build up, how much alcohol that you're able to handle. And when asked by Mr. Byers, cross-examination of the defendant said, well, initially he said, well, I drank a little more than I normally do. He later backed up and said, I drank more. Dr. Siegel would also said, the first thing I want to do is interview the defendant. The defense has stretched considerably the testimony in this case. We don't know for sure that Jeremy's DNA was on that gun. 1 in 6,900. That gun had been in Santa Fe. That gun had been all throughout creation. That gun had been to Arizona. Even if it was Jeremy Martin's DNA, that makes no difference in this case whatsoever. There's a reasonable and rational explanation for why it would be there when Jeremy was trying to protect himself. The state has not conceded anything. The state does not concede anything. The defense has set forth different defenses. They conflict with one another. What they're trying to tell you was, well, it's self-defense, but if it wasn't self-defense, then it's intoxication. Those two defenses are entirely different. Self-defense requires an intent to kill. That's what it requires. It requires an intent to kill. That's the primary defense as I take it. And then there's one on self-defense. And I would ask Mr. Prindle to put this up on the stand, and you can see I put some red marks on it. Self-defense. There was an appearance of immediate danger that someone was going to be subjected to serious bodily injury or death. I submit that's not here. There's no evidence, credible evidence, that would support that. Probably the more important line and requirement for you to find self-defense is what I've underlined in its entirety. And it deals with what a reasonable person would do. I submit to you that what was done to Jeremy was not something a reasonable person would ever do. And you can review the jury instructions when you go back. That's the standard. That's the law of the state of New Mexico. And if I might, Mr. Prindle. What you have before you is a copy of the first-degree murder instruction. And I've underlined parts at the bottom dealing with a calculated judgment. It can be very brief, a very short period of time to make a conscious decision, to weigh and balance, and then to make the decision and intend to kill. That can be as in short a period of time as what I've just taken it to describe. I submit to you, when that line of murder was crossed, given the number of shots, the number of times the defendant had to pull that trigger, the measured shots, the shots to the back, the defendant, I submit to you, had the time, took the time to think about what he was doing, to weigh and balance the consequences, particularly as a trained law enforcement SWAT officer, to take the life. Once that calculated judgment is made, I submit to you that based upon the evidence, the verdict is first-degree murder. You also have before you second-degree murder, which doesn't require that time to think or that time to calculate without sufficient provocation, as long as that's not there. The difference here, and let's put it this way. Within the room, if there had been a shot, maybe, just maybe, that would be second-degree murder. But once that line of murder was crossed, those additional shots were fired at a disabled, unarmed man, a fellow Santa Fe deputy sheriff. All of a sudden, it became entirely different. line of murder once crossed and those shots were fired, not only did it become the line of murder, it became the line of first-degree murder. There is no speculation about it. The Las Cruces Police Department did an admirable job in this case, right from the response of Connie Hurd, who went above and beyond and is a true hero for doing everything she could to save Jeremy Martin's life, to the officers who went up a stairwell not knowing what they were going to face, and they were able to bring the defendant down safely, to the investigators who went in and conducted a thorough investigation, to the officers who found the shell casings, to the officers who documented all of the evidence. That's a third defense the defense attorneys want you to buy into, and that is to hold the Las Cruces Police Department on trial. That's not a defense to murder. That's not a defense to first-degree murder. Ladies and gentlemen of the jury, the state accepts its burden of proving a case beyond a reasonable doubt. I oftentimes view that as being when you go to buy a house, it's an important decision. Do you automatically go in, run in, and buy the house? No. You get inspections. If it has a septic system, you do the inspection. You do a termite inspection. You do a roof inspection. And then you make a decision that that's a house I want to buy. Ladies and gentlemen of the jury, you can do the same thing here. And I submit to you on behalf of the state that the verdict in this case is first-degree murder. I too took an oath to represent the people of the 3rd Judicial District of the state of New Mexico. Mr. Byers, Mr. Prindle, and my duty is just about finished. In fact, it is finished. You took an oath as jurors to carefully consider the evidence and to render a fair and impartial verdict. And I respectfully request, based upon the evidence before you, that that verdict be guilty of first-degree murder. I submit to you that's what justice requires. Thank you.
Thank you, Mr. Berger. I am now going to ask you to retire to the jury room to begin your deliberations. You're going to be provided a copy of the jury instructions, and the exhibits that were introduced into evidence will be made available to you. Let me at first suggest to you that it would be the court's preference for the gun not to go back into the jury room. However, if during the course of your deliberations you want to review the weapon, then again just make that request and we'll make it available to you. Prior to beginning your deliberations, you're going to select one of you to act as the fourth person. That individual will preside over your deliberations and will speak for the jury here in the court. Forms of verdicts have been prepared for your use. You're going to find them immediately in back of the instructions. Again, please remember that as it is associated with either a determination on the second-degree murder charge or the voluntary manslaughter, there are what are referred to as special interrogatories. You will have to answer a question related to the use of a firearm, as was explained in the instructions. Please remember, although the court isn't necessarily comfortable with this approach, but I didn't want to interrupt the closing arguments. There were exhibits, demonstrative exhibits that were being used during the closing arguments asking you to look at certain aspects of certain jury instructions. Please remember, the charge is that you look at the instructions as a whole, each individual one. You aren't to select parts of an instruction and disregard others. You look at the instruction in its entirety. Let's see, you're going to take these verdict forms to the jury room. You've reached a unanimous agreement as to your verdict. The foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits here to the courtroom. Please remember, the decision that you make, the verdict that you arrive at, is to be based on the evidence that you have been presented, and including the exhibits that were introduced as evidence. It's not uncommon for a jury to perhaps submit a question to the court, asking the court to answer certain questions. What you will base your decision on, you already have in front of you. The court cannot, the parties cannot supplement the evidence in any way. You're not to be engaging in any kind of investigation. You're not to be speculating. Your decision, the question that you will answer, is based on what you have already heard and what has been introduced as evidence. If for any reason you have a question regarding the jury instructions, then certainly you can send out a question to the court, and the court will do its best to respond to you. But let me first encourage you. If you're having any issue related to the interpretation of the instructions, just use your collective common sense in terms of how to interpret it or how to apply it. If you still have a question, then yes, go ahead and send it out, and the court will attempt to respond to it in the best way that you are able to. One of the very first things that I told you at the very beginning of the trial is that this is a trial to a jury of 12 persons. You certainly know that there are more of you than that. There are alternates that are selected in every case. They are never identified because they have to be just as committed to understanding these proceedings and the evidence that's being presented just as much as the original 12. The court cannot risk, should anyone be in an accident, have a family emergency, become ill, that this work would have gone for naught. So these alternates are selected, never identified, and you already know that we lost a member of the jury within the first 2 days of the proceedings. So an alternate steps into that position. The remaining alternates in this case are Mr. James Lopez, Miss Mandy Kristen Murray, and Mr. Isaac Camacho. You three will remain here in the courtroom with us. The rest of you are now excused to begin your deliberations. As you know, we're in the middle of the noon hour. Lunch has already been ordered for you. I believe that it's either already arrived or should be arriving in just a few minutes. So you now can begin your deliberations, and if you'll accompany Mr. Narciso, if any of the 3 alternates that I identified have anything remaining in the jury room, then just please let Mr. Narciso know, and he'll retrieve those items. Thank you.
Please rise, the jury.
difficult in terms of how to respond to being identified as an alternate. Sometimes, if the trial is taking us a day or a couple of days, and to just a little bit, there's two ways to react. One is that you're happy because you get to be released early. The other is that you're disappointed that you can't see this all the way through its conclusion. Well, you've dedicated the last 10 days to this effort, so I know that it's a disappointment not to be able to participate in the deliberations. However, as the alternates, your responsibility to these proceedings have now come to an end. I am going to compliment all three of you because of the dedication that you show. Part of the court's responsibility